The marble corridor of the Hargrove Federal Courthouse fell silent in the particular way that marble corridors do. Every sound stripped down and amplified, until even a breath felt like a confession. It was the kind of building that made people straighten their spines without being asked. Columns the color of old bone rose from the polished floor to a ceiling 3 stories above. Morning light pushed through tall, arched windows in long, pale rectangles, and the air smelled faintly of lemon oil and old paper and something else. Something institutional and cold that no amount of lemon oil ever quite covers. She sat alone on a bench outside Courtroom 4, not slumped, not anxious, perfectly still, the way still has to be practiced to look that natural. She wore a charcoal blazer over a cream blouse, small gold earrings, dark slacks pressed sharp at the crease. A leather portfolio rested across her knees, closed. Her hands rested on top of it. On the lapel of her blazer, barely visible in the dim corridor light, sat a small round pin-dark enamel, a ring of gold stars around a central seal, small enough to miss, small enough that most people did. Dr. Renée Okafor was 47 years old. She had a stillness about her that some people found calming, and others found deeply unsettling without being able to explain why. She was waiting. Officer Craig Beaumont saw her from the far end of the corridor and made a decision in approximately 4 seconds. Later, in the proceedings that would end his career, he would struggle to articulate what that decision was based on. He would say he had a gut feeling. He would say she looked like she didn't belong. He would say the courthouse had been having issues lately with unauthorized visitors using the public galleries as a place to loiter. He started walking. Beaumont was a courthouse security officer. 12 years on the job, broad through the chest, with a habit of carrying his chin slightly elevated that had nothing to do with posture and everything to do with the way he moved through a building where he believed he was the primary authority in any room he entered. He kept his right hand loose near his radio. He walked like a man who had never once doubted his own read of a situation. He stopped 3 feet from her bench. "Ma'am," his voice was designed to carry, "you need to show me your reason for being in this corridor." She looked up from the portfolio. Her eyes were steady, the kind of eyes that had heard a lot of different versions of that sentence and were no longer surprised by any of them. "I'm waiting," she said. "Waiting for what?" "Court to open." Beaumont's chin came up another half-inch. "This is a restricted area during pre-session. Public access opens at 9. You need to wait downstairs in the lobby. I'm aware of the public access schedule." Her voice was even, not aggressive, not apologetic, simply accurate. "I'm not here as a member of the public. And who are you here as?" She looked at him without blinking. Something in the corridor seemed to tighten. "Someone with authorization to be in this hallway," she said. What Beaumont heard in that answer was defiance. What was actually in that answer would not become clear to him until it was far too late to do anything about it. He reached for his radio. Craig Beaumont had been a courthouse security officer at the Hargrove Federal Courthouse in Columbus, Ohio for a dozen years, and in those 12 years he had developed a taxonomy of people who came through the building. There were lawyers. He could spot them by the rolling briefcases and the rehearsed impatience. There were defendants, nervous, overdressed, or underdressed, never quite right. There were witnesses, confused, clutching subpoena papers like boarding passes to a flight they didn't want to take. There were clerks and paralegals and the miscellaneous army of people who kept a federal courthouse running. And then there were the people he referred to in his head, though never aloud, as the not supposed to be here's. He had a sense for them. He would have told you he'd developed that sense over 12 years on the job, honed by experience, refined by instinct. He was wrong about where that instinct came from, but he was right that it was consistent. Dr. Renée Okafor had triggered it from 40 feet away. He keyed his radio as he stood over her. "This is Beaumont on the 4th-floor corridor. I need a check on." He paused, looking at her. "An unauthorized individual outside Courtroom 4. No credentials visible." The radio crackled. Static. The morning shift was thin. 10-4, Beaumont. "Stand by." She hadn't moved. The portfolio remained across her knees. The gold earrings caught the corridor light. She was watching him with an expression he couldn't quite categorize. Not fear, not anger. Something more like patience, weighted with something else he couldn't name. "I'm going to need to see some ID," Beaumont said. "You didn't ask for ID, you asked why I'm here. I'm asking now." "I heard you." She didn't reach for anything. "I'd like to understand the basis for the request first." Beaumont felt the familiar simmer that started just below his sternum whenever someone asked him to explain himself. In his experience, People who asked security officers to explain themselves were either lawyers making a point or people trying to make his job harder. The basis, he said, keeping his voice controlled, is that this is a secure area during pre-session hours and you are not displaying any credentials authorizing you to be here. I see. She nodded slowly, as if genuinely considering this. And when you say displaying credentials, you mean visibly, the way visitors display their day passes. That's correct. I'm not a visitor. Beaumont's jaw tightened. Ma'am, I'm asking you one more time to produce identification or accompany me downstairs. I understand what you're asking. Her voice hadn't changed in temperature. I'm telling you that I'm authorized to be in this corridor, and that if you escort me out of this building, you will have made a significant procedural error. Is that a threat? The word landed wrong. She looked at him with something close to genuine curiosity. No, she said. It's a description of what will happen. Beaumont squared his shoulders. 12 years of instinct told him this was a woman who had rehearsed this conversation, who was looking for a confrontation she could leverage. He'd seen it before. You let people like that win once and the whole courthouse became a negotiation. Stand up, please, he said. We're going to walk to the lobby. She didn't stand. I'd prefer not to, she said. That wasn't a request. I know. She looked up at him calmly. That's the problem. From the far end of the corridor, the elevator chimed. Neither of them looked toward it. They were locked in a silence that had taken on the particular density of silences that will later be replayed in formal proceedings. What Beaumont did not know, could not have known from where he was standing. With his 12 years of courthouse taxonomy and his certainty about who belonged in which rooms, was what that small, enamel pin on her lapel actually was. He had seen it. His eyes had passed over it. His brain had filed it under jewelry, dismissed it, moved on. He should have looked closer, but he hadn't. And the thing about not looking closer is that it only costs you when the thing you didn't look at turns out to matter enormously. 2 floors below, the Hargrove Federal Courthouse was assembling itself for the day. The clerks moved between offices with armloads of files. A paralegal from the DA's office stood at the security desk arguing quietly with the morning supervisor about courtroom assignments. In the basement, the building's facilities manager was arguing with a contractor about the lobby's recessed lighting, 3 bulbs dead in the same fixture for the second time this month. Nobody in the building at that moment was thinking about the 4th floor corridor. But the 4th floor corridor was where everything was about to go wrong. Beaumont's hand moved to her arm. Not roughly. He would emphasize this later. In the IA report. In the federal complaint. In the various proceedings that would succeed one another with increasing severity over the following months. Not roughly. A firm guiding contact. The kind used to redirect an uncooperative subject who had declined multiple verbal requests. She looked at his hand on her arm. She looked back at him. Remove your hand, she said now. You're being escorted from the premises. You are making a mistake. Her voice was still level, but something in it had shifted. Not anger, not panic, but a kind of finality. I am going to give you one more opportunity to correct it. Walk with me. No. Beaumont tightened his grip. In the far end of the corridor, a door opened. A young law clerk stepped through it with a stack of files, saw what was happening, and stopped moving entirely. Her name was Amara Baptiste. She was 23 years old, and she had been working at the Hargrove Federal Courthouse for 4 months. She stood absolutely still, files pressed to her chest, watching. Beaumont didn't notice her. He was already moving, steering the woman toward the elevator. She did not fight him. She did not raise her voice. She walked. He would later claim she walked voluntarily. The corridor cameras would later demonstrate that the walking was the result of a wrist-lock grip that left bruising. She walked, her portfolio still under one arm, her posture unchanged, her face unreadable. In the elevator, Beaumont pressed the lobby button. The door closed. The floor indicator ticked downward. 1, 2, 3. The lobby. He walked her toward the security desk. The morning supervisor officer, Karen Yates, looked up from her computer with the expression of someone who had seen a lot and was briefly interested. Found her on 4, Beaumont said. No credentials. Refused ID, refused to leave. He let go of her arm. She can wait out front until whatever she claims to be waiting for comes to get her. Yates looked at the woman. The woman was setting her portfolio on the security desk with the practiced calm of someone who had been waiting for a surface to set her portfolio on. May I ask your name? Yates. The woman opened her portfolio. She took out a document, a single folded sheet, official letterhead, the seal of the United States District Court embossed at the top. She placed it on the desk in front of Yates and flattened it with one hand. Yates read it. Her face changed. She read it again. "Officer Beaumont," Yates said slowly, her voice acquiring a quality it had not previously had. "When you found this individual on the fourth floor, did she state her reason for being in the building?" "She said she was waiting for court to open. Refused to elaborate. Refused credentials." "Did she show you anything?" "No." Yates looked up. She looked at the woman in a way that was entirely different from the way she had looked at her 30s ago. There was something in her expression that looked a great deal like the early stages of alarm. "Did you at any point ask for her judicial credentials?" "She's not a Beaumont." Stopped. Yates pushed the document across the desk toward him. He picked it up. He read the first line. The second line. His face did not change outwardly, but something behind his eyes shifted. A rapid, involuntary recalibration of every assumption he had made in the last 20 minutes. He read the third line. He put the document back on the desk. The lobby, with its chiming entry turnstiles and its fluorescent light and its contractor arguing about recessed bulbs in the far corner, continued its ordinary morning around him. None of it touched him. He was standing very still, holding the edges of a catastrophic misread. "Who called you up there?" Yates asked. Her voice was quiet now, the kind of quiet that has carefully removed all judgment from itself while still being fully aware. "I know one. I was on fourth floor patrol. I saw her." Yates looked at the woman. "I need to make some calls." The woman nodded. She picked up her portfolio from the desk. She looked at Beaumont, one clear, level look, neither unkind nor warm. "I'll be upstairs," she said. She walked back toward the elevator. Beaumont watched her go. When the elevator door closed behind her, the lobby felt markedly quieter, though nothing about the lobby had changed. Karen Yates was already on the phone. Beaumont could see her at the security desk, turned slightly away, one hand pressed flat to her ear, as if to keep the words from escaping. Her free hand moved to a notepad. She was writing something. Whatever she was writing, she wrote it quickly and underlined it. Beaumont replayed the morning. He replayed it with the particular mental motion of a man searching for the version of events that holds up. The version where the read was defensible, where the response was proportional, where the outcome is a form to file and a notation and nothing more. He replayed it 3 times. The version he was looking for did not materialize. He thought about the pin. He had seen it. He was certain he had seen it. Small, enamel, gold. He had categorized it as jewelry and moved on. But in the replaying, he could see it differently. The ring of stars, the seal at the center, the specific language that the courthouse ID guide described as a judicial officer's credential. He had read that guide. He knew he had read it. That knowledge lived somewhere in him, filed under things that apply to other situations. Not this one. He was beginning to understand that this one was every situation. Yates came off the phone. She looked at him across the lobby with an expression that was careful and controlled and not at all reassuring. "Officer Beaumont," she said, "I need you to remain in the building. Don't leave the floor." "What's happening?" "Someone is coming to speak with you." She paused. A few somebodies. He had no idea, none at all, what was about to happen. But Karen Yates, already dialing an extension, had a very clear idea, and she was moving fast. The fourth floor of the Hargrove Federal Courthouse had filled, in the way fourth floors fill on a court morning, purposefully, with briefcases and low voices and the particular tension of people who are either about to argue something or about to listen to someone argue something. Attorneys clustered near the courtroom doors. Clerks moved with the focused urgency of people whose actual job begins about 30 seconds before everyone else's. A few early members of the gallery had already taken seats inside Courtroom Four, arranging themselves in the dark wood benches with the diffident patience of people who understood they were observers in someone else's drama. The bailiff that morning was Sergeant Harold Webb. Sergeant Webb had worked the federal courts for 21 years. He was a compact man with close-cropped gray hair and the kind of face that gives nothing away. Not because he was hard, but because 21 years of courtroom work had taught him that a bailiff's face is part of the institution. It should look like the building looks impartial, certain, unmovable. He was reviewing his morning docket when the call came through to his desk phone. He listened. He asked 2 questions. He listened to the answers. He put the phone down. He stood there for a moment, looking at nothing. Then he picked up the phone again, dialed the building supervisor's extension, and said 4 words that set in motion a chain of events Beaumont had no capacity to predict. "Send him up here." Beaumont received the instruction from Yates via radio. report to the fourth-floor bailiff station. His first read of this was that it was routine, a formal account of the incident, a report to file. That was the shape of these things. Someone claims unauthorized access, security responds, a form gets filled out. He'd done it dozens of times. He rode the elevator up alone. The fourth-floor hallway was more crowded now. Attorneys and clerks and a cluster of 3 people in suits he didn't recognize. He moved through them toward the bailiff station, which was the anteroom adjacent to the main doors of Courtroom Four. Webb was standing at the anteroom doorway, not sitting. Beaumont. His voice was neutral. Sergeant Webb Beaumont came to a stop. You wanted to see me about the fourth-floor incident? Come inside. Webb stepped back to let him in. The anteroom was small, a desk, a monitor showing the courtroom interior, a phone, a coat rack. It was also occupied by 2 other people. The first was the courthouse administrator, Diane Marsh, a woman who worked in an office on the 2nd floor and whose presence in any room tended to mean the paperwork would be complicated. The second was a man in a dark suit who had the look of someone who worked for an organization that valued precise language and unhurried movement. Beaumont looked at them. He looked back at Webb. What is this? This is a preliminary inquiry into your conduct this morning, Marsh said. Her voice was pleasant in the specific way that pleasant voices sometimes are when the situation underneath them is not. I responded to an unauthorized individual in a restricted corridor during pre-session hours, Beaumont said. Standard protocol. Walk me through it, Webb said. Beaumont walked through it. He kept his account factual, sequential. He'd been trained to give factual, sequential accounts. He described the individual on the bench, the refusal to produce credentials, the refusal to leave, the escort to the lobby. When he finished, Webb nodded once. He looked at the monitor, the feed from the interior of Courtroom 4. Beaumont followed his eyes. Inside the courtroom, in the gallery, sat the woman from the 4th-floor bench. She had the same portfolio, the same blazer. She was speaking quietly with 2 other people, a man in a dark suit, a woman in attorney's dress. Beaumont watched her for a moment. Who is she? He said. His voice had changed slightly in register. He didn't know it yet, but he was beginning to understand that the question he had asked was not a simple one. Webb didn't answer immediately. He let the silence run for a beat longer than was comfortable. That, he said, is who I'm about to announce. He turned toward the courtroom doors. Stay here, he said. The doors opened. Beaumont watched through the small window set into one of them as Webb walked to the front of the gallery and stopped. The assembled attorneys and clerks and observers settled. The low murmur of the room descended. Webb drew breath. His voice, trained by 21 years to reach every corner of a federal courtroom without effort, filled the space entirely. All rise for the Honorable Renée Okafor, United States Federal Circuit Judge, 3rd Appellate Circuit, Office of the Chief Judge of the District, Columbus Division, who will be observing these proceedings in official capacity. Today, the room rose. Every person in it rose without hesitation. The attorneys, the clerks, the observers in the gallery. Every single one. In the automatic physical acknowledgement that a federal courtroom offers to a federal judge, which is not optional and not ceremonial, but is instead the baseline recognition of an authority that is built into the structure of the room itself. Beaumont stood at the window. He watched them rise. He watched her, Judge Okafor, stand from her seat in the gallery and acknowledge the room with a brief nod. The way a person acknowledges a room that they understand is acknowledging them. He watched the small pin on her lapel catch the light as she turned. The ring of gold stars around the federal seal. The pin he had noticed. The pin he had dismissed. The pin that had been telling him the entire time exactly who she was. He stood at the window and he watched all of this, and he understood, with the delayed, total clarity of a man who has just watched a domino chain complete itself, what he had done. Harold Webb came back through the anteroom door with the exact expression he always had, unmovable, impartial, like the building. Diane Marsh had a tablet in her hand. The man in the dark suit had a phone pressed against his ear. Officer Beaumont, Marsh said, and the pleasantness in her voice was gone now, replaced by the plain tone of institutional process. The building's corridor camera system has been reviewed for this morning's pre-session period. We have footage of the incident you described. Beaumont said nothing. It differs from your account in several particulars. She held up the tablet. He could see the timestamp in the corner of the paused video. He could see his own figure in the corridor, his posture, his approach. He could see, without the ability to deny it, the grip on her arm, the wrist lock, the forced direction toward the elevator, The portfolio clutched under her arm as she moved, not voluntarily, but because she had no other option. She was not displaying credentials, he said. His voice had the quality of something losing pressure. She is a sitting federal judge, Webb said. Federal judges are not required to wear their credentials to walk in their own courthouse. I didn't know that. That is a significant part of the problem, Marsh said. A federal judge in this building has complete access to every corridor, every anteroom, every gallery, every floor, at any time without presenting credentials to any building security officer. That is federal protocol, and it is in your training documentation. I thought she was a visitor. Marsh looked at him over the tablet. On what basis? The question sat in the room. Beaumont opened his mouth. He closed it. Because the honest answer, the answer his training would not let him give and his record would not let him afford, was the same answer the corridor camera had already provided more eloquently than any words he could construct. It was the same answer that Webb and Marsh and the man on the phone and the entire apparatus of inquiry now focused on this anteroom already had in their possession. He had seen a black woman sitting alone on a bench. He had decided in 4 seconds that she did not belong. He had been wrong in a way that could not be attributed to ambiguity or circumstance or the honest fog of a difficult call. He had been wrong in the way that a pattern is wrong. I need to call my union rep, he said. You can do that, Marsh said. She was typing something on the tablet. We'll give you the room, but be aware this inquiry is proceeding regardless, and you should know that there is a secondary matter we will be discussing with you when you're ready. Beaumont looked at her. What secondary matter? Webb and Marsh exchanged a look. Judge Okafor, Webb said carefully, has been on the federal circuit for 11 years. Prior to her elevation to the Third Appellate Circuit, she served 9 years as a district court judge in this building. Beaumont was very still. She presided over cases from this courthouse, Marsh continued, including administrative and disciplinary cases referred through the civil service track. The man on the phone lowered it from his ear. He looked at Beaumont. 3 years ago, he said, and his voice, when he finally used it, had the flat informational quality of someone reading from a case file, a formal misconduct. Complaint was filed against you at this district's administrative office. Racial harassment, excessive force. The case was reviewed by the district judge at the time. Beaumont had been in this building 12 years. He had filed reports, sat in briefings, attended annual trainings, and processed an uncountable number of ordinary days. He had a memory for cases and incidents the way most people have a memory for weather, general impressions, occasional specifics. But he remembered that case. He remembered it because the complaint had been filed by a black public defender who had been stopped by him in this very corridor in circumstances not entirely different from this morning, and who had, unlike this morning, been someone he could dismiss. No lapel pin, no portfolio, no federal title that Webb would announce from the front of a gallery. He remembered it because it had been reviewed, and because the reviewing judge had not dismissed it, had, in fact, issued a formal finding of probable misconduct, ordered remedial training, and placed a notation in his file that would follow him for the duration of his career. He remembered the reviewing judge's name. He had never, until this morning, attached a face to it. He was attaching one now. The man in the dark suit watched him do it. Take your time, he said, but I'd make that call quickly. The union representative arrived at the building at 11:47. His name was Dennis Parrott, and he had been representing courthouse security officers for 16 years. And in 16 years he had seen a fair number of bad days. He carried a briefcase and an expression of professional calm that he maintained the way skilled carpenters maintain a good plane, with constant small adjustments and a lot of practice. He sat with Beaumont in the anteroom on the 4th floor and he listened to everything. He did not speak for the first 7 minutes. When Beaumont finished, Parrott set his briefcase on the desk, opened it, and looked at the preliminary inquiry documentation that Marsh's office had already prepared. The corridor footage, Parrott said. Yes, you gripped her arm. I was escorting. You gripped her arm. Parrott's voice was not unkind. It was simply precise. She declined. You applied a wrist lock restraint. This is visible in the footage. She was non-compliant. She was a federal judge in her own courthouse. He paused. On what grounds was she non-compliant? The answer, again, was the same answer that kept returning, no matter which angle Beaumont came at it from. He had no grounds. The grounds he had given himself had been made out of the material of his own certainty, which was not a substance recognized by any disciplinary code or procedural regulation or court of law. The secondary matter, Beaumont said, the complaint from 3 years ago. Parrott nodded slowly. She reviewed it. Yes. She found probable misconduct. Yes. Parrott was quiet for a moment. I need you to understand something, he said finally, about the position you are currently in. You physically removed a federal judge from her own courthouse after she informed you that she was authorized to be present based on an assessment that she did not belong in the space she was occupying. You are on record having done something similar 3 years ago, and the record of that prior incident was reviewed and substantiated by that same judge. He closed the briefcase. The department does not have significant room to maneuver here. What does that mean? It means I can advocate for you through this process. I will. That's my job. But I need you to hear me clearly. The outcome of this process is not going to be what you're hoping for. Beaumont looked at the wall. What is it going to be? Parrott picked up his briefcase. Let me call the department administrator, he said, and then I'm going to call you back with a conversation you're not going to enjoy having. The formal inquiry hearing convened 10 days later. The room was a second-floor conference space, longer than it was wide. A single row of windows along one wall, a table running its length. On one side, Diane Marsh, the courthouse administrator, flanked by two representatives from the Federal Building Security Oversight Office and a senior investigator from the Department of Justice's Civil Rights Division named Owen Caruso. Across from them, Beaumont, in the dress uniform of the Courthouse Security Service, and Parrott with his briefcase. At the head of the table, as was customary for proceedings involving a formal complaint by a federal judicial officer, sat a presiding officer from the Circuit Administrator's office. His name was not important to Beaumont. What was important was the folder he carried and the methodical way he opened it, which suggested the contents had been reviewed many times and were not going to surprise anyone in the room. Officer Beaumont, he began, this proceeding addresses two matters. The first is the incident of the 14th, the unauthorized physical removal of a federal judicial officer from the secure corridor of this building. The second is a prior substantiated complaint from this office, issued 3 years ago, and the question of whether the conduct documented on the 14th constitutes a pattern consistent with that prior finding. Beaumont sat with his hands flat on the table. We have reviewed the corridor footage extensively, Caruso said, leaning forward. He had a measured voice and the kind of stillness that suggested he had asked harder questions in harder rooms. I want to give you an opportunity to address the footage directly, because what the footage shows is specific. He placed a printed still frame on the table. Beaumont looked at it. This is the moment you made initial contact, Caruso said. At this point, had the individual stated she was not a visitor? She said she wasn't here as a member of the public. She told you she had authorization to be in the corridor. She didn't show me anything. Federal judges do not show credentials to building security, Caruso said. This is documented in your training materials. Did you ask her to clarify her role in the building? I asked who she was here as. Her response, and this is on the audio track, was that she was someone with authorization to be in the hallway. You interpreted this as confrontational rather than as a statement of fact. She refused to identify herself. She identified herself as someone authorized to be there, Caruso said. She declined to do it in the way you were requesting, which would have been a visitor presenting a day pass, which she was not. Because she was not a visitor. He paused. Officer Beaumont, in your experience, who typically declines to present credentials the way visitors present them? Beaumont knew the answer. It was in his training materials, in the section on court personnel. He said nothing. Staff, Caruso said. Attorneys, officers of the court, judicial personnel, people who belong to the building in a capacity other than visitor. He sat back. You saw a woman on a bench who did not present as a visitor. You concluded from this that she did not belong, rather than concluding that she might belong in a different category. I made an error in judgment. Yes, the question before this inquiry is the nature of that error. Caruso picked up another document. Your prior complaint. 3 years ago. Can you describe that incident? Beaumont described it. His account was briefer than his account of the 14th had been. He kept his eyes on the table. The finding in that case was probable misconduct, Marsh said. Remedial training was ordered. The training was completed. It was completed, Beaumont confirmed. Did the training address the specific pattern documented in both incidents? Caruso said. Parrott interjected. Officer Beaumont completed all mandated training in full. That's not what I asked. A quiet pause. The training addressed unconscious bias in security assessment, Beaumont said. Did it change your assessment process? Parrott started to interject again. Beaumont held up a hand, a small, quiet gesture. Parrott stopped. No, Beaumont said. The room was very still. It was the first completely honest thing he had said in the proceeding. The presiding officer looked at him. Thank you for that, he said. His voice was measured and not unkind. The inquiry appreciates directness. He made a note. The recommendation from the inquiry arrived 14 days after the hearing. Beaumont was at home when Parrott called to read it to him. He sat at his kitchen table. The call was not a long one. The recommendation was termination, permanent revocation of courthouse security certification, immediate referral to the Department of Justice Civil Rights Division for assessment of whether the conduct on the 14th, in combination with the prior substantiated complaint, met the threshold for federal civil rights charges under Title 18. Notation in his permanent federal employment record, full cooperation with any civil action Judge Okafor chose to pursue. Parrott read it without editorializing. When he finished, Beaumont asked one question. Is she filing a civil suit? That, Parrott said, is not something I would know at this stage. The answer, though neither of them said it, was already visible in the shape of things. The DOJ referral, the pattern finding, the corridor footage, preserved and cataloged and available to any attorney who chose to file a request for it. The answer was yes. It was always going to be yes. The only question was what it would cost, and that question had a very specific answer that Beaumont spent the next several weeks beginning to understand. The civil rights case moved through the federal court with the unhurried deliberateness of federal cases, which is to say, it moved with absolute certainty in a direction that Beaumont could not alter or redirect or slow, no matter what he did. The case was assigned, with the clinical impartiality of the court's docketing system, to a district judge, not to Judge Okafor. She had recused herself from all proceedings related to the incident, as was required, and had issued a public statement through the court's media office that was 3 sentences long, factual in every respect, and contained the word remedy twice. The assigned judge was the Honorable Marcus Trent, a 20-year veteran of the federal bench who had been in the same law school cohort as Renée Okafor, and who, according to everyone who appeared before him, took civil rights cases with an attentiveness that had at various points been described by defense attorneys as thorough, exhausting, and unsparing. The case before Judge Trent had one unusual feature. At the preliminary hearing, the first time Beaumont sat in a federal courtroom as a defendant rather than as an officer, Judge Trent had reviewed the case file and made a ruling on the admissibility of prior conduct, evidence that admitted the full record of the 3-year-old complaint, including the finding of probable misconduct, and including the specific language of the remedial training order, which stated clearly that the mandated training was intended to address a documented pattern of racially differential assessment of who belonged in which spaces. The word pattern appeared in that document 4 times. Judge Trent used it twice in his ruling. Beaumont sat at the defense table and listened to the word reverberate. 2 years ago, it had been a word in a file. 12 years ago, it had not existed in any formal sense. Now, it was a structural element in a legal argument that was being built around him with the careful, unarguable precision of a building, designed to stand, his attorney private, not the union. The union had withdrawn support after the inquiry recommendation had prepared him for the hearing, had told him what to expect, had walked him through the likely arc of the proceedings. What the attorney had not been able to prepare him for was the moment when Judge Trent referenced, for the record, the specific corridor footage timestamp at which Beaumont had made his initial assessment. 4 seconds, Judge Trent said, reading from the forensic review. He looked up at Beaumont over the bench. The forensic analysis of the footage indicates that your initial assessment, the one that determined she did not belong in, the corridor was formed within approximately 4 seconds of first visual contact, before any interaction, before any words, before any attempt to verify or investigate what you were observing. He set the document down. 4 seconds, he repeated, not rhetorically, but with the weight of someone marking a specific datum in a specific record for a specific purpose. The question before this court is not whether Officer Beaumont made an error. He has acknowledged that he made an error. The question is whether that error constitutes a deprivation of rights under time, color of law, and whether it reflects a pattern that rises to the level of a civil rights violation. He looked at the room. given the documented prior complaint, the prior finding of probable misconduct, the confirmed failure of mandated remedial training to alter the documented pattern, and the specific nature of the conduct on the 14th, physical removal of a federal judicial officer from her own courthouse on the basis of an assessment formed before any interaction took place. This court finds that the threshold has been met. Beaumont's attorney placed a hand on his arm, a steadying gesture. Beaumont was looking at the gallery. He had not expected anyone he knew to be there. He was wrong. In the second row, behind the bar, sat Amara Baptiste, the law clerk who had been standing at the far end of the fourth-floor corridor on the morning of the incident, files pressed to her chest, watching. She had been subpoenaed as a witness. She had given her account clearly and without embellishment. She was 23 years old, and she had described exactly what she had seen. Behind her sat the public defender who had filed the complaint 3 years ago. The complaint that had started a file, the file that had become a finding, the finding that was now a pattern, the pattern that was now evidence. His name was Marcus Webb, no relation to the bailiff. He was 31. He had spent 3 years assuming that complaint had gone nowhere. He had been wrong about that. He watched the proceedings with the expression of someone watching something complete itself. In the front row, directly behind the prosecution table, sat a woman that Beaumont had not seen since the morning of the 14th. She wore a different blazer today, dark navy matching slacks, the same small gold earrings. The enamel pin was on her lapel again. The ring of gold stars around the federal seal, perfectly visible from across a room, if you were looking at it, which he had not been. She was sitting with her hands folded in her lap, her posture exactly as it had been on the fourth-floor bench, composed, still, waiting for the proceeding to arrive at its conclusion, which it was about to do. Judge Trent delivered the formal ruling the following Tuesday. The courtroom was quiet, in the way federal courtrooms are quiet when they are full, every sound absorbed into the wood and the marble and the accumulated gravity of the space. Attorneys in their chairs, clerks at their stations, the gallery filled with observers who had followed the case in the court filings and who understood, because the filings were unusually clear, what this ruling represented. The court finds for the plaintiff on all counts, Trent said. He read through the findings. The civil rights violation, the pattern determination, the damages assessment, the injunctive orders addressed to the Building Security Service as an institution rather than to Beaumont alone. The injunctive orders required mandatory review of all security personnel files for similar pattern findings, implementation of specific credentialing protocols for judicial officers, and a structural audit of building security practices. The damages award was personal liability, uncovered by his former employer because his certification had been revoked and his status at the time of the incident had been reclassified through the inquiry process as acting outside the scope of authorized duty. It was a number that took a minute to process. Beaumont sat and listened to it. The gavel came down. In the gallery, Marcus Webb, the public defender who had filed a complaint 3 years ago and had assumed it went nowhere, let out a breath that he had not realized. Until that moment, he had been whole. Amara Baptiste, beside him, pressed her hands flat on the gallery railing. She was 23. She had been in this building 4 months when she stood at the end of the fourth-floor corridor with files pressed to her chest and watched a security officer make a decision in 4 seconds that he could not walk back. She had given her account of it clearly and without embellishment, and now she was watching the building issue a formal answer to that account. She thought about the woman on the bench, the way she had sat, perfectly still, the portfolio across her knees, the small pin catching the corridor light. She had known, Amara realized. Had known from the beginning how it would resolve, had sat in that courthouse, her courthouse with the patience of someone who understood that the building would eventually say what it needed to say. It just needed time to say it. 3 months after the ruling, on a morning in early spring when the trees outside the Hargrove Federal Courthouse were doing what trees in Ohio do in April, committing to something. Finally, after all that ambiguity, Harold Webb arrived at the fourth-floor bailiff station at 7:45. He had a new name on his docket, one that he had known for 11 years. He prepared the courtroom the way he prepared it every morning, checked the gallery seating, confirmed the recording system, reviewed the case list. Then he walked to the anteroom and stood in the doorway for a moment, looking at the changed space, new protocols on the wall beside the door, new credentialing procedures printed on courthouse letterhead, new awareness training documentation, signed by every security officer in the building. The building had done what buildings do when they are forced to look at themselves. It had adjusted. Down the hall, the bench outside Courtroom 4 sat empty in the early morning. The pale light came through the tall windows the same way it always had. The marble held the cold the same way it always did. Nothing about the corridor had changed in any visible way. Same columns, same flooring, same institutional stillness. But the protocols on the anteroom wall were new, and the building knew it. At 9 o'clock, he walked to the front of the gallery. The room settled. He drew breath. All rise for the Honorable Renée Okafor, United States Federal Circuit Judge, Third Appellate Circuit presiding. The room rose. She came through the side door, robes flowing, the long, unhurried step of someone who had walked into this room many times and would walk into it many more. She took her seat at the bench. She arranged the documents before her with the precise economy of motion that had characterized every version of her that had ever been in this building. The law clerk, the assistant prosecutor, the district judge, the appellate judge. She looked at the room, and the room looked back. "Be seated," she said. It was not a new voice. It was the same voice that had spoken in the fourth-floor corridor 3 months ago, even direct, entirely certain of itself. The voice that had said, "I am telling you that I am authorized to be in this hallway." The room had taken a long time to hear it. Now it had. She opened the first file and got to work. Afterward, not much afterward, just the ordinary kind of afterward that follows a morning court session in a federal courthouse. The hallway conversations, the clerks with their stacks, the attorneys checking phones. Amara Baptiste stood near the elevator and waited for her colleague to finish a conversation at the other end of the hall. The elevator opened. Judge Okafor stepped out with her portfolio. She was heading back to the circuit offices on the 6th floor. She walked the way she always walked in this building, not quickly, not slowly, with the particular ease of someone in a place they belong to and that belongs to them. She passed Amara. She slowed. "Ms. Baptiste," she said. Amara straightened involuntarily. "Your Honor?" The judge looked at her for a moment. The gold earrings, the small pin, the portfolio. "You gave a good account," she said in the proceeding. "I told them what I saw." "That's the whole job," the judge said. "Most people forget that." She continued down the hall. Amara watched her go past the bench where it had started, past the corridor camera that had recorded everything, past the long pale rectangles of morning light coming through the tall windows, toward the elevator at the far end. The building was quiet around her. The marble corridor did what marble corridors do. It held. Justice doesn't always arrive loud. Sometimes it walks calmly down a courthouse corridor in a charcoal blazer, sits on a bench with a portfolio across its knees, and waits for an institution to remember what it's for. Craig Beaumont spent 12 years in a building that was built to make things right. He never understood that the building included him in that mandate, that the obligation to see clearly, to assess fairly, to ask one more question before reaching for the certainty of your own assumptions was the foundation of every authority he had ever been given. He made a decision in 4 seconds. It cost him everything. Renée Okafor sat on a bench and waited. She had been waiting, in various forms, for a very long time. For institutions to do what they are built to do, for buildings to say what they need to say, for the weight of a system designed around fairness to eventually, actually, come to rest on the side of fair. She had learned to be patient. She had also learned to be a federal judge. In the end, the courthouse did what courthouses are for. It heard the case. It weighed the evidence. It ruled. If this story settled something in you, the kind of thing that needs settling, share it with someone who believes that quiet people in public places deserve to be seen correctly, not in 4 seconds, but in full. Subscribe and stay close, because the next story is already waiting, and it is worth your time.